Let's start. By way of this petition, under Section 34 of the Arbitration and Conciliation Act 1996, the petitioner challenges an award dated 18/02/2019, rendered by a learned sole arbitrator under the IN domain name Dispute Resolution Policy (herein after referred to as the INDRP). By the impugned award, the learned arbitrator has declined the petitioner's claim for transfer of the disputed domain name https://zoai.in/ by the respondent to it para. It emerges from this decision that an award can be set aside on grounds of apparent bias or propensity to decide one way rather than the other. While the test has been formulated in different ways in the judgments, it is clear that apprehension of bias has to be tested on the yardstick of reasonableness as seen from the perspective of the affected party. Any doubt regarding the arbitrator's fairness or neutrality must be justifiable, not whimsical or fanciful, and must give rise to a real danger of bias or partiality. Para. Having regard to the above principles, I am of the view that the arbitrator's inclusion of his own name in a Hall of Fame based on his decisions against the complainants in 4 INDRP disputes does give rise to such a justifiable apprehension as to his neutrality. Para. The judgment of the Supreme Court in Shivananda Pathak 34, even while upholding the test of predisposition, prejudice and bias, noted that the preconceptions about general questions of policy and supra note 4 para. Signature not verified digitally signed by Situ Nagpal Singh, date 03/07/2023, 19:47:52. Discretion may not be sufficient to invalidate a judicial adjudication, although the question has not been conclusively decided in the said judgment. Even from this perspective, in my view, the present case crosses the permissible latitude available to an arbitrator. The inclusion of the name of the learned arbitrator in the Hall of Fame is based upon the fact that he has denied the maximum number of INDRP complaints. This is not a general comment on applicable law or policy, but a specific indication on how such cases should be finally decided. The learned arbitrator has expressed a view that denial of INDRP complaints is per se a positive achievement without reference to the applicable law, policy or evidence. The very least that a litigant is entitled to accept is that an arbitrator would be agnostic to the result of the arbitral proceedings, whatever his or her predisposition may be on particular points which arise for adjudication. Para. Mr. Bokshi drew my attention to an assertion in the learned arbitrator's affidavit dated 10/02/2023 that he has in fact decided 23 out of 29 arbitration cases in favor of complainants certified. This, however, does not persuade me to a contrary view. The fact that the learned arbitrator has decided cases in favor of complainants does not find mention on the website established by him. It appears to me quite evident that in the opinion of the learned arbitrator, denying complaints is a more laudable achievement. Stop. Thank you. Jai Hind. Jai Mera Bharat.
Thank you.